first case to come before the court this morning is Reginal Johnson. You each have 15 minutes to present your arguments to the court, and you, as the appellant, may reserve up to 5 minutes. And hopefully, our brains are not as frozen as our hands and fingers, and we can all think here today, because that's what I said when I walked in. I think everything's frozen on me. So, at any rate, so when you're ready to proceed?
Yes, Your Honor. And may it please the court, Attorney John Toth on behalf of appellant Reginal Johnson, and I would like to reserve 5 minutes of rebuttal. We're here today. Mr. Johnson did a plea on a plethora of major drug offender and RICO statutes, felony of the first degree. Some of those mandatory minimum 11 years, and a host of other felony of the first degree drug offenses. Mr. Johnson's case was sitting in the Court of Common Pleas for around 1.5 years. After 11 odd months, when it was set for trial, it was set for suppression. The original trial counsel found out after disclosure, let me back up. Criminal Rule 16, there was a non-disclosure of a confidential informant in the matter. The witness set up the buys in the case. 2 weeks before trial, this witness was disclosed. Counsel had to withdraw because they had a conflict of interest. That attorney had represented that witness in this matter. Mr. Johnson hired new counsel. Fast forward another 5 months. Mr. Johnson took a plea in the trial court. That plea was for an aggregate, agreed 15-year sentence. During the plea colloquy, basically a lot of it was they put the cart before the horse. They came to an agreed 15 years, and then they backtracked trying to fashion how to do that. During the colloquy, they addressed judicial release. And the trial court had stated along the lines of the earliest that Mr. Johnson would be eligible for judicial release was after 11.5 years. And Mr. Johnson did plead guilty to the indictment that the grand jury handed down. That included felonies of the 5th degree, misdemeanors, and 5 or 6 felonies of the 1st degree. So he agrees to the aggregate of 15 years. But during that colloquy, the trial court inquires on judicial release and tells him 11.5 years.
Well, and the trial court, I think, pretty clearly said to him that he didn't even think this was applicable.
Correct.
But basically, out of abundance of caution, he was going to go over with him just in case.
Correct. And I think that's where a crux of the issue is because when the trial court did start that dialogue with the appellant, there was never a concrete answer because the court had never decided how they were going to sentence the appellant.
Right, and I think both you and the state agreed in your briefs that the court could have fashioned a sentence that would have been wherein he might have been eligible for that type of release, correct?
Correct. And it would have been a little bit of work to get there, but in the end, the appellant was sentenced on one of the major drug offender mandatory minimum 11 years, and then also the RICO. That was run consecutive to a 4-year sentence on one of the felony of the 1st degree traffickings that wasn't a mandatory minimum 11.
And he was not sentenced above and beyond what the plea agreement was,
correct? But then again, there is not anything in the plea sheets or in the colloquy saying that he's not allowed to ask for judicial release as part of his aggregate sentence. And that's the hardest thing about the case is it's silent on that. I know a lot of times, just go one county east in Cuyahoga, that's part of a plea on one of these cases. hey, listen, as part of this agreement to this case right here, you're going to agree not to apply for a judicial release. Or go west one county to Erie County, and that's commonly part of the actual agreement between the parties is agree to a 5-year term, and we're not going to object or file a response on the judicial release issue. Here, as soon as that colloquy starts and we go down that route, Mr. Johnson actually asks questions about it. And he says, Your Honor, can we go over the judicial release again? And since there's never an answer, whether it's 11 and a half years, he could apply, not, that's a major motivation. That's backing it up, back to the facts. Mr. Johnson, this is his first time at the rodeo. And
Can you speak to the statement that his counsel made regarding 11 years, the response made by counsel?
let me get the exact wording of it. The nod, he says, we're giving a nod to the minimum 11 years. I was kind of baffled by that, but my problem was there was still that agreed 15 years. And that's what, when I was fashioning my brief on the matter for Mr. Johnson, was really the focus on that inducement of, listen, you could apply after 11 and a half years, it's 4.5 years off. And that inducement is what got him to make the plea, so it wasn't voluntary, knowingly, or intelligently. And I do believe that that statement speaks to that. And my second assignment of error was, this is more of a, there is not a lot of case law on it, and I will concede that point, but I fashioned that this was an abuse of discretion from the state's standpoint. And the reason being, the case had gone on for 11 and a half months, 11 months. And when the state decides to not disclose a witness, and then all of a sudden comes in a week and a half, 2 weeks before trial, and says, hey, this is our witness, now counsel has to withdraw, I believe it puts a duty on the state then to look through their file. They have the witness's name, they have their information. If he's an informant, he has pending cases or had a pending case, and they're the only one that's holding that knowledge. And that there should be some sort of duty placed on to say, in this case, Mr. Bradley, I just want to let you know that instead of being on the eve of trial, that there is an issue here.
So this is a plain error argument?
And this is, and I know that this isn't I scoured, but since the new criminal rule 16 with the non-disclosure, there is not a lot of case law on this. But my argument was that this kind of situation does promote some sort of duty. When the state's taking that position of not disclosing, then they're also taking the responsibilities of, they're the gatekeeper. They're holding it. They should have that duty then to advise the court, have a hearing on the matter, but not after 11 and a half months, not when you're set for trial.
Is there anything in the record to show that the state was acting in bad faith, that there was some sort of bad?
No, there is not. If anything, it's more of a, we can get to it all of a sudden when we're subpoenaing our witnesses before 10 days before trial, we realize that. And no, but this isn't one of those malicious intent. Nothing in the record would support that. But we do have Mr. Johnson on the record then making a statement basically that he got bamboozled. Because he was really, he worked very closely with Mr. Bradley, Mr. Stefanik, and then he's set for trial, about to go, and then he's calling around trying to find somebody who can handle it. And he found Joe Morse, who he's out of Middleburg Heights, or he's in Middleburg Heights.
I guess it was my recollection from the briefs that Attorney Bradley had noted the conflict and withdrawn from representation several months before the trial. Am I incorrect in that?
No, it was actually set for suppression, then a trial in December of 2014. Then Mr. Bradley withdrew and it started back from scratch. And then in May of that year, then it was set for suppression trial again with that new counsel. So, I mean, basically, once Mr. Bradley withdrew, it's not, the trial court didn't say, hey, you have 4 weeks to go to trial now, because this case has been in our docket. It did allow them to work the case out for a substantial amount of time, and the appellant does concede that also. I mean, it wasn't like they came in and said, hey, you're going to have a jury here in a month, especially given the circumstances with it being a felony in the first degree.
You have 5 minutes. Whatever, 15 minutes.
Thank you very much, Your Honor.
Good morning, Your Honor. May it please the court. My name is Natasha Guerrieri, and I represent the appellant of the state of Ohio. I apologize for my voice. I'm just getting over sickness. First, with regard to Mr. Johnson's first assignment of error, just in regards to addressing judicial release, as Judge Hensel pointed out, the trial court did have the ability to craft a sentence which conceivably could have allowed Mr. Johnson the ability to apply for judicial release. And at that point, the trial court had not yet stated, and this was during the plea colloquy, not actually at the sentencing, stated that it could conceivably be a possibility. It might be, but this is a mandatory time situation, so just in case the sentence is crafted in that way, I'm going to inform you about judicial release. And there was a case that it was somewhat similar out of the 11th district, although in that case the language was contained in the plea agreement, in which it stated that the defendant in that case might become eligible at some point in time in the future for judicial release, and the state at that point would not oppose any sort of judicial release at that point. And in the 11th district, in that case, in State versus Miller, the court there found that the language there did not validate the plea, that because the language there did not necessarily indicate that he indeed was eligible for judicial release, that was not an inducement to the plea in that case. And the state here would argue that's a similar situation here, that there was no inducement to plea here, just simply because the trial court stated this might be a possibility in the future, although I highly doubt that that's the situation. And furthermore, Mr. Johnson would have been required into this case, because it was a non-constitutional issue with regard to judicial release, to show some sort of prejudice as a result. Prejudice in this case meaning that he would not have pled guilty but for the statements of the trial court regarding judicial release. Here there's no argument to that effect that I was able to find within the brief, that but for that fact, Mr. Johnson would not have pled guilty. In fact, it appears from the potential maximum sentence that Mr. Johnson could have received, it appears more of the inducement was the fact of receiving a 15-year sentence versus the potential of a 57-year sentence. That was the true inducement of his plea at that time. And then with regard to the second assignment of error, again, that would be plain error if in fact at all, although the state would argue that because Mr. Johnson did not raise the issue before the trial court and did not make an argument that but for the purported prosecutorial misconduct, that the result of this matter would have been different, that he actually waived that argument. However, in just reviewing it on the merits for the court here today, that would be under a plain error argument. And here again, Mr. Johnson was required to show how but for this purported prosecutorial misconduct, that he would not have entered the plea of guilty in this matter. And here that first issue that he points to is the CI information. And it appears from looking at the record that at that December pretrial, It was at that point that both the state and the defense discovered that the CI in this case was represented previously by Attorney Bradley. Upon learning that information, Attorney Bradley immediately petitioned the court to be removed from the matter, and that was granted without any issue by the trial court. Mr. Johnson was able to obtain new counsel and was given time to prepare for the matter, to not proceed immediately to trial as previously scheduled. Furthermore, all of the information that was not disclosed through that non-disclosure agreement, the trial court did order the state to provide to the defense, and the state did do so. Therefore, Mr. Johnson and his attorney were apprised of all of the information prior to entering into and entering a plea of guilty in this matter. Therefore, the state would submit that Mr. Johnson was fully apprised of everything. His attorney was well advised of everything that was happening. They discussed it and made a decision that, based upon all the facts, that this 15-year prison term in exchange for a guilty plea was appropriate for him, and it was not in any way different based upon, this situation would not have been any different based upon any purported misconduct by the state. Therefore, the state would argue that Mr. Johnson's plea, it was valid, and would request that this honorable court uphold his sentence in this matter and overrule any assignments of error. Thank you. Thank you, Your Honors.
You have a little less than 5 minutes.
Thank you. May it please the court, just in response to that. First, just going off of the prosecutorial misconduct is, it's as somebody who regularly practices criminal defense, one of the things that happens in these drug cases is when you get that witness list, as defense counsel, the first thing every attorney looks to do is take those witnesses and run them through their conflict evidence. See, hey, has this person been a witness? Have they been a client? Is there some sort of relationship? Now, because it went 11 months before counsel could do that, that's the prejudice right there. Mr. Johnson hired counsel, was comfortable with counsel, and there was that wait of 11 months. And that's what the appellant is arguing was that misconduct, is when you take that burden away from defense counsel, then you have to do something. You can't just sit on it. And if you have the witness name in the state's file, it's as simple as taking that person's name and running it through Lorain County Court of Common Pleas. And it takes 30 seconds, but you're taking away that ability for trial counsel to do that.
Well, how is he prejudiced by it?
Mr. Johnson's argument is that he wasn't comfortable with Mr. Morse.
But would the whole case have turned out differently had he had a different counsel to begin with?
Arguably, I mean, he was a lot more comfortable going forward on the motions to suppress with his original counsel.
How does this comfort level equal prejudice? I don't see how those two things are the same.
I'm not disagreeing with you at all. And I understand that. That was one of the appellate issues that I had to crack. I mean, I'm not saying it was supported by 20 years of common law. It isn't. But it's out there. And then when it comes to the judicial release part, when the trial court inserts itself and then begins talking about judicial release with the appellant, that is when that duty comes in then, to get the information right. Did the court have to go over judicial release with the appellant? No. But when it's fashioning, listen, you might be eligible in 11 and a half years, you might not ever be eligible, you do have a duty then to tell the appellant the right way.
Okay, we say you might not ever be.
But that's not a concrete answer here. This is 3.5 years.
Does the trial court have a duty to accept the plea agreement that's presented to them by the state?
No, not at all.
And so they have no duty to accept what is provided to them.
Correct.
And that's not done at the plea colloquy anyway, that's done in sentencing.
Correct.
So anything could have happened between the time the plea was given to the judge at the plea hearing and the time the sentence was imposed.
Correct.
They didn't have to be the same thing.
The court could have given him 11 years and not followed that agreed sentence. They could have given him arguably 57 years.
So by giving him, that it's possible that you could get judicial release or not.
And when you're sitting there at the plea colloquy, and that's what you're using as your basis right before he puts his guilty plea in, you might be eligible for judicial in 11 and a half years. That's exactly where the spark
Or you
is.
could get 57 years.
Correct. But it's how the inducement made it, not knowingly, intelligently, or voluntarily.
So it could actually be worse if it goes back, right?
Absolutely.
Okay, just wondering.
No, it absolutely, I mean, and I've gone over that, and I don't know, because of the way this was set up, this court, it did not look like there was a PSI. And I know that the way the case law works, if the PSI came out horrible, yeah, absolutely, there could be a worse sentence. And Mr. Johnson knows that. Okay, thank you.
Thank you. Council, we will take the matter under advisement and issue a written opinion that will be sent to both of you, and you can also check on our